consider whether in such circumstances the evidence already tendered can be retendered. There are circumstances where if a hearing has proceeded, the evidence will not be available in terms of documents or even in terms of time span.
Memory loss? Is that what you're talking about?
Yes, my lady, I believe so. I would also say that it is not my day-to-day practice, I would agree. Thank you.
But you're doing very well.
Yes. I practiced this, as I said, long time ago.
Yes.
Yes.
Yeah, but you talked about prejudice to the defense. Does prejudice also to the prosecution matter?
Yes, prejudice to the prosecution would matter because you have to consider the expenses, the prosecution, the difficulties the prosecution would have to go through to secure its witnesses or even investigating officers.
Now that you have told us what you need to consider before you make your finding, from that explanation, what is mandatory under Section 200 of the CPC and what is not mandatory?
I think what would be mandatory is the prejudice to the accused person.
Are you obliged to make a finding that the case must start de novo?
It is not mandatory that I make that finding.
All right. So all that is mandatory, Judge, is that you inform the accused person of his or her rights under Section 200 of the CPC, but it's not mandatory that the matter must start de novo.
Unless prejudice is established.
Thank you. Thank you, CJ.
Good morning. Good afternoon, Judge.
Good afternoon, Honorable Attorney General.
Yes. Although you have said that you are not very versed in criminal law practice, but I would ask you very simple questions.
Thank you, Honorable
Or just
Attorney
one.
General.
In common law system or tradition, in litigation, there's something called separation of powers amongst the agencies.
Yes.
The investigator, the prosecutor, and the arbitrator, the court.
Yes.
However, with emerging issues in criminal law, globalization of criminal law, we are now seeing a convergence of those roles. Can you give us examples of areas where the roles of the three arms of government or those three parties are converging?
I think one area where they converge is in witness protection, so that the three parties would be, in their best interest, required to agree to situations where witnesses ought to be protected. Another area is in circumstances like of plea bargaining, where in lieu of a higher charge, parties may enter into negotiations and there can be acceptance to a lower charge, like in restorative justice.
Any example from investigation powers or investigative powers?
A good example...
Especially where coercive measures are required.
A good example would be like in anti-corruption cases, where we may want to compulsorily acquire property that is illegally acquired besides the criminal process. Looking at the expenses involved if we were to go into the processes of acquisition, like in civil processes of asset recoveries, it would be easier for the charged person to plead a lesser charge or to a lesser sentence and agree to surrender the property to the state.
Thank you. But likewise, as the roles of the three arms of government converge, we also have now an emerging trend where criminal procedure and civil procedure is converging. In dealing with complex criminal cases, borderless criminal cases, please give us two examples.
where civil processes converge with criminal.
Yes.
I think one of them would be in the area of trafficking of human beings, where the victim may be entitled to certain recoveries, such as compensation, and at the same time, the culprit is liable in criminal law.
Do we have instances where they converge in the same case?
Yes, I think in a criminal case, there could be need for prevention measures.
Okay, and finally, you're familiar with common law tradition and civil law tradition.
Yes.
Likewise, because of complexities of crime and development in criminal law, we have areas where common law and civil law are converging. Please give us examples. You might want to look at international institutions, international law.
I think a good example would be like in the cases before the ICC, the crimes against humanity, where there may be undermining of social justice, and at the same time, there are serious commission of crimes against humanity.
Any examples with regard to procedure? Where common law and civil law would converge?
In terms of procedure,
Yes.
in international criminal justice system.
Thank you.
Thank you, Chair. Judge, I heard you say that one of the attributes of a good judge is a judge who's courageous and who can make a decision that is not that may not sometimes be popular and also care about the consequences.
Yes.
Did I get you right?
Yes, Commissioner. Not care about the consequences.
Yes.
But not to be courageous enough to make the decision.
Yes.
Even if it is unpopular, maybe to the majority of the community.
Okay.
Provided the judge owes fidelity to the law and the Constitution.
And one of the accusations that are made against judges or arguments is that they seek to substitute the decision of those that are elected to represent the people with their own decisions.
Yes, Commissioner, I'm following.
And that will be now an argument that will be made that if you make a judgment or make a decision and you don't care about what the popular will or what the popular sentiment is that sometimes a judge can or judges make decisions that are against actually the will of the electorate.
As long as the decision is in accordance with, for example, furtherance of rights,
yes,
then that would be appropriate. Not that the decision goes outside the tenets of law, but the situation that you refer to would appear to be one in the arena of judicial overreach.
Yes, now I want us to discuss that. Now, I'm sure you're aware about the case of KTDA versus NSSF.
Yes.
I don't know. Did you sit in that bench?
I did not sit in the bench, but I'm aware.
Oh, you're aware of it. You are aware of the decision. Now, that is a decision that nullified an entire act that sought to transit the NSSF to a new sort of arrangement in terms of managing retirement and pension.
Yes.
And when that judgment was made, the old act preserved the way pension would a pension for about 300 billion that was saved under the old act was not transited, so that when that declaration was made and the entire act was thrown out, there was no remedy that was left to pensioners. Would you say that that was responsible?
I would say that was responsible, because even where unconstitutionality of a statute is found,
Yes.
the operation of that may be suspended. Not that the act then becomes constitutional, but that the court should care that there is no what the courts have called chaos in the running of affairs of the state, so that we preserve stability.
So in that decision, that was not done, so that, you know, having maybe somebody who's younger like you, myself, that might not matter, but having an 80-year-old wait for that issue to be settled might not be prudent, because I mean the everyday counts in their life, because most of this I'm just discussing this just so that I get your philosophy on in terms of what are consequences of making judgments. You have people who are very old and who are possibly depending on pension. They don't have any other source of income. You declare an entire act unconstitutional, and in the intermittent, there's nothing that preserves them. So would you say that is responsible?
That would not be responsible, and the apex courts, the Court of Appeal and Supreme Court, have guided that it would be appropriate to suspend, to give the
declaration of
political
invalidity.
arms, the
Yes.
executive and the parliament,
Yes.
a chance to correct things and avoid instability in the interim. So the order would be that steps be taken within a particular time while stability is retained.
Okay. So is that important in terms of judging, that even if you owe fidelity to the law, fidelity to the law also means that there is also fidelity to the rule of law, and not to create chaos in terms of management of a sector or a service that is sought to be regulated by a statute?
I agree, Commissioner. And one might want to look at the nature of the decision made. Is it that the application of the statute was unconstitutional? That is the impact. Or whether the challenged statute was inherently unconstitutional.
But where there is no transition and under statute for such a large sector as retirement or pension is moving from one statute entirely to the other, and then there's some little of it is preserved for continuity to pay pensioners, doesn't that play into a judicial mind?
I agree that the appropriate thing is, while declaring unconstitutionality, measures are put in place to suspend the implementation of the unconstitutionality finding, so that there is stability and not chaos.
Okay. And won't that also be one of the values in terms of interpretation of the law in maintaining of good governance and the rule of law?
Yes.
Okay.
Yes.
Now, I wanted to ask whether you are aware of a doctrine known as the predominant test, where a court, let me read for you a quote so that you respond to it. Or let me just paint this scenario. You have a dispute about financial, about a charge or a transaction that has been done between a chargee and a charger with respect to a title.
Yes.
And the matter comes before court. Would that be a matter for ELC or for the High Court?
Yes, you'll want to look at the dominant dispute in the whole matter.
Yes.
And if it is dominantly land, then it would go to land. But if it is dominantly commercial, then it would go to the High Court. And so the best thing is to let the court, which enjoys jurisdiction on the dominant aspect of the dispute, to handle the matter.
Okay. Now, in Court of Appeal, what would you say is the greatest strength in that court that you would bring as a judge with your experience?
I bring the tools of interpreting the Constitution in a manner that furthers constitutionalism and human rights. I also bring the aspects of responsiveness, as I mentioned, responsiveness in making of the decisions, and the efficiency, because one big problem we have in the Court of Appeal is backlog of cases.
Okay.
And so I bring efficiency in terms of managing the docket and resilience in making sure that we reduce the backlog.
And one of the things that you might meet there is that when you now join the court, you join it as the junior most judge, if you succeed. Meaning that it's very important about how you work in terms of chemistry with the other judges.
Yes.
How do you react to a situation whereby if you go to a bench and you find that for one reason or the other, one or two of the members of the bench that you are in don't take your opinion seriously?
I think this is an aspect in collegiality.
Yes.
And it is about effective communication. As I mentioned, giving your opinion clearly to the other parties, to colleagues well in advance, and also taking time to read what their position is, and also leveraging on the leadership of the court.
What if you are totally on the opposite side? You are the junior most member of the bench. There are two other judges, and one is on the extreme. The senior most is on the extreme. You're on the extreme. So there is need to converge, because there is no decision that come without a convergence.
Yes.
How would you navigate that sort of situation?
I think the best thing to do in such case is to do my preparation effectively, look at analyze the issues in the case, then look at the precedents, and look at the applicable law or constitutional provisions, and then seek to persuade my colleague.
Thank you. Thank you, Chief Justice.
Justice Mrima, Honorable CJ, just one question. You've been asked what you bring to the court, and you've enumerated quite a number of things. You do not bring integrity?
My lady, I had mentioned it in passing in my opening remarks, and I say integrity is very important, and it's a virtue that I bring to the court.
Thank you.
Judge, welcome once again.
Thank you, Commissioner.
I'll have a very short discussion with you. I know in your sitting as the ELRC court, you handle constitutional matters, and you deal with all issues pertaining the issues of rights and fundamental freedoms. Now, if you run through the Bill of Rights, you realize two categories. Some of those rights and fundamental freedoms refer to every person, and some refer to citizens, only citizens. Maybe you can give an example or two of each, and maybe why that distinction?
Some may be political rights. For example,
political rights, they fall under which one? Every person or citizen?
That one fall under, the political rights would fall under every person, has a right to vote, and I'll imagine only citizens would vote.
Yes.
So that in terms of interpretation, it imposes a qualification that it is not a right applicable. There are certain conditions, preconditions to be ascertained before the right is enjoyed. But just reflecting about the question you raised, Commissioner Judge, I would also think about the issue of horizontal implementation of the rights and the vertical implementation, those which are vested in the government, and government is required to take steps, and those for which even private individuals are bound to respect. So that while Article 10 says that the Bill of Rights is binding to all, there are those that would be vertical rights imposing a duty on the state. Like when Article 47 says Parliament shall make a law to implement the article, then that is an imposition on the government. But in other provisions, for example, discrimination, it would be a right which binds every person, not even with considerations of citizenship or qualifications. It is of that, and it can be applied even horizontally and not just vertically.
Okay. This is your area of specialty. The difference between contract of service and contract for service, what is it?
Yes, a contract of service imports the traditional contract of employment, which implicates the minimum terms and conditions of service in the Employment Act. But for service imports the meaning of an independent consultant, also known as consultancy or independent contractors.
Okay, and lastly, in your introductory remarks, you had started, not introductory, but I think you are responding to a question raised by Commissioner Judge Sichale. And you had started talking about criminal matters before ELRC and magistrates or something like that. Can you clarify that?
What I meant is that under the Employment and Labor Relations Court Act, the Act is vested with jurisdiction to enforce the employment laws.
Yes.
And these employment laws also provide for offenses.
Yes.
And so Section 29 of the Act empowers the Chief Justice to make certain, by gazette, jurisdiction to be imposed on magistrates. And one such jurisdiction that was imposed on magistrates is the handling of criminal matters in employment disputes.
Yeah.
The issue I said has not been tested,
Yeah.
is in event there is a prosecution under those offenses,
Yeah.
would the appeal come to the ELRC or the High Court? That is what I meant, Commissioner.
Okay, and what position do you take on that?
I have no immediate position because I'll have to listen to the arguments.
Okay.
Yes, Commissioner.
Okay, thank you
It
so
has
much,
not been
Judge.
tested.
I wish you the very best. Thank you, Madam Chair.
Yes, thank you very much. Judge, I want to test you a little bit on your familiarity on matters family law. The Supreme Court has had the opportunity to settle some questions on the best interests of the child. In particular, the Supreme Court has set out some guidelines which a court ought to apply when they are balancing the child's best interests and parental rights and responsibilities. Just wondering if you're familiar with those guidelines, which were in the case of MAK versus RMAA, and maybe you can tell me one or two of those considerations or guidelines that a court must consider when balancing between the child's best interests and parental rights. What ought a court look into?
Well, I may not have really read that particular decision, my lady. I think in considering parental parental responsibility as against the best interest of the child, we need to consider the economic realities of the parties, so that it is not that the provision is imposed, like to provide beyond what is within the means of the parent. And secondly, a party to the proceedings, either of the spouses, should not introduce measures which make it more expensive for the other party, unreasonably so.
Apart from financial considerations, what other consideration, if you can name one, that the court would have to look at when balancing, apart from financial?
The court would have to look at because when we are talking about parental responsibility, we are looking at capacity of either parties to take care of the child, and they have equality of rights in to do so. So we may want to look at the best suited of the parties, the spouses or the parents to the child, who is best suited to take care of the child.
Thank you.
Thank you, Commissioner.
Thank you, Chair. Good afternoon once again, Judge.
Good afternoon, Commissioner.
Okay, we've reviewed your sample writing, and they focus mainly on employment, though they range from disability, disability rights, diplomatic immunity, and constitutional appointments. You write well, they are well-reasoned, coherent, and you're able to link facts to the applicable law. The use of precedence is sound, and your tone is measured and impartial. And depending on the context, because I've looked at the 5, they reflect right-based and formalistic approaches. Though I took note that the recent one is a 2018 decision, so I was wondering, you've not done anything past 2018, though I have read your decisions. Maybe you can respond to why you chose to submit not very recent sample writings.
Yes, if I respond to that, Honorable
Yes.
Commissioner, I just picked on the decisions based on what I thought would show my structure in writing and my legal reasoning, and which may not be fundamentally different from today. But in that regard, I have provided the schedule of decisions I've made in the recent past, in the recent past 3 years, and which I'll leave with the Commission.
Okay, thank you. For many years, as a country, we used to apply the common law doctrine known as the pleasure doctrine. And in recent times, the executive, that is the presidency at the national level, and governors at the county level, still hold that certain offices require political confidence, loyalty, and policy alignment. What is the place of this doctrine in the current constitutional dispensation?
Honorable Commissioner, the pleasure doctrine finds its roots in the inherited position that public officers held office at the pleasure of the crown, the monarchy. And in the retired constitution sections, if I recall, 24 and 25 stated that the president had public officers held office at the pleasure of the president, and that the president would abolish public office subject to contract. That is subject to accrued rights under contract. But all that has changed in the new constitution, because we have moved away from supremacy of parliament and the sovereignty of the monarch, so that the constitution provides that the people are sovereign in Article 1, and Chapter 6 of the constitution introduces the concept of servant leadership. And so the doctrine of holding office at the pleasure of the crown has been substituted with the doctrine of servant of the people, and the doctrine that the public officers are removable at pleasure has been substituted with the due process, like in Article 236, so that public officers can no longer be victimized. So the whole idea is that there should be a reason for a public officer to be removable from office. And these are the holdings, if I recall, in the case of Richard Bwongo Birir, in which I decided and went to the Court of Appeal, and the Court of Appeal said whether the pleasure doctrine. And in another case, Cecilia versus Nyeri, in which the Honorable Chief Justice sat, the Court of Appeal then said there must be a reason for a public officer to be removable.
Thank you. I'm told to beat that. I don't know whether that's true. Governor may respond to it when this time comes, that when you're during appointment, you have your appointment letter and undated resignation. I don't know how true that is. Thank you, Judge.
Thank you, Chair. Good afternoon once more, Judge.
Good afternoon.
So I want to read you a quote and then maybe get your feeling about it. The quote goes, "If we really want high performance in our organization, the solution isn't to entice people with a bigger carrot or threaten them with a longer stick. We need to understand the intrinsic motivation." I'll read it again. If we really want high performance in our organization, the solution isn't to entice people with a bigger carrot or threaten them with a longer stick. We need to understand the intrinsic motivation. Now, I want to ask if you agree with this statement, and secondly, whether the performance appraisal system in the judiciary is aligned to this statement.
I think this statement is making reference to the arena of transformative leadership, where we identify the players in an organization and seek to ensure that we get the best out of them. And to get the best out of them is to identify their capacities and inspire them to exploit the space for improvement. To that extent, I would hold that quote to be correct. As to whether this has been done in the judiciary, I accept that it has been applied in the appraisal system of the judiciary, because the judiciary has embraced a system of initiative taking, encouraging staff to take initiatives and introduce innovative measures, for example, towards backlog reduction. I would also mention that it is not always true that by increasing, for example, the pay margins, the staff would be very happy, but it is by getting the best out of the individuals so that we can exploit the space for improvement.
So in your view, the framework that we have, other than giving you room to innovate, does it also elicit from you what it is that motivates you to perform?
Yes, and staff are best motivated. Of course, rewards and sanctions play a role in motivating staff. And if I understood the quotation, it says that it is not only rewards and sanctions.
That is correct.
But also looking in the intrinsic.
What is it that makes
inspires people to move into a better performance in terms of meeting their goal for innovation and taking initiative. Yes.
Okay, so in your view, do you think there's room for improvement in that direction in our performance appraisal system? Or do you think we are there already and we are good to go?
I trust there is room for improvement, because we can increasingly, during the open appraisal system, request staff to tell us in very practical ways, setting targets for which they think they'll take initiative. Yes.
Okay, thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you, Commissioner.
Now, should judges be involved in budget preparations, and to what extent?
I think judges should be involved in budget preparation, not just as a civic duty imposed on due to every citizen, but also because that way they can map out the impactful application of resources. So, for example, talking about access to justice, the judges are best placed to prioritize not just the physical outreach of the courts in terms of circuits and stations and universally designed courts in terms of infrastructure, but even other matters of access to justice, like what I have come to learn and I'm actively involved in digital ICT access. And here we are talking about not just writing the plain English that I talked about, but also judgments which can be accessible by persons with disability. And that can only happen if judges are involved in budget making and they can prioritize so that we can then have more access to justice and also apply resources in points where it is going to be very impactful to delivery of justice.
Okay. Now, could you also tell us how you will apply the leadership and responsibilities listed under Chapter 6 as a judge?
Yes, the Chapter 6 requires that state officers bring honor to the office and that public service is not to rule but to serve. And so that brings to bear the requirement of judges to embrace virtues such as humility, magnanimity, and honesty, not just in their conduct, but even in the way they write the judgment, so that the judgment brings out all the issues honestly. The judgment is in what I'll call texture and form, impressing those kind of virtues. But more important, it imports the requirement for accountability. And by accountability, judges should submit themselves, for example, not to run secret bank accounts in foreign lands. They should submit themselves to financial declarations, and judges should also submit themselves to payment of taxes. This, I think, are such of the things that would impress Chapter 6 on the part of the judges.
Thank you. Finally, what is your view on mentorship, and when does it amount to interference?
I'm not so sure I've got the question, Honorable Commissioner.
What is your view on mentorship? Do you believe in mentorship?
Yes, mentorship is one of my core levels of collegiality, because I look at collegiality at 4 levels. First is training, to know what happens around here. And secondly is coaching, to do it the way we do it here. And thirdly is mentorship, the one you ask about, which is doing the way champions do it. After mentorship, if you are able to do it the way champions do it, then we can, on a very good footing, engage in the 4th level of exploration. And so I look at mentorship as a critical element of collegial engagement, where we strive to perform like champions, making delivery of justice excellent. Yes, Commissioner.
When does it become interference?
So when we are engaged in mentorship, it might become interference if maybe the mentee feels that unmanageable expectations have been imposed, like unmanageable timelines, because it is not easy to be a champion. You must program your work, you must do very many things to become a champion. And so for those who are not ready to be champions, they just want to do it the way we do it, it might to them feel I have been outstretched. Yes.
Thank you, and I wish you all the best.
Thank you.
Thank you, Honorable Chair. Good afternoon, Judge. I have
Good
a few
afternoon,
questions for
Commissioner.
you. As the PJ ELRC, what would you say has been your greatest challenge while leading the team at ELRC?
I think the greatest challenge of building a high-performing team is to build the collegiality in the 4 levels that I have defined, so that other than walking the talk, you need to get into the subsets of the performance, the registries. You need to get into redefining the culture of performance, and then motivating and inspiring so that we can have the same work. The challenge of leadership is to work through other people, and that challenge needs a lot of effort.
So would you say you're there, or it's work in progress?
I would say I am there, looking at how we have, I believe in ELRC we have the most efficient registries, we have the best case clearance rates, we have eaten into the backlog on very good margins. I believe we have developed a high-performing team in the ELRC, looking at the annual reports.
Okay. If I was to walk back to Milimani at the ELRC registry, what is the one thing people there would tell me they don't like about you?
I think they will tell you Judge is a perfectionist, wanting to do things very clearly. And reflecting about my time before I became PJ, I would take time to do my drafts and deal with them within my timelines. But when I became a principal judge, this time was donated out to leadership. And so to deal with this, I had to go back and look at my team and empower my legal researchers. Not that I don't take responsibility, but they can be able to do the preliminary work to a level that I have built trust in them, and therefore reduce my timelines and my engagement on preliminary matters in writing an opinion. And therefore, that way, I have developed trust, even in my court assistants, so that they are able to flag out and do the preliminary work properly and free some time on my part. And so by delegating and building a high-performing team and building trust while retaining my responsibility as a judge, particularly in drawing opinions, becomes then the way I've handled it. But I would say that would be the one weakness that they might tell you, that
Okay.
I have tough timelines.
Okay.
Yes.
All right. Thank you, and I wish you the very best.
Now, how familiar are you with international and regional legal instruments relevant to your field?
Relevant to?
To your field.
Yes, I have been involved in the development of a sectoral committee on public service for the ESC, and I have also paid attention to the African Peoples and Human Rights Charter and the UN and the operations of some of the UN agencies, like the ILO, which sets international labor standards and which are critical in what I do today.
What is your view on the arrest of the Venezuelan president?
I would say the arrest of the Venezuelan president within the realm of accepted general principles of international law and treaties, it would be legal, in my opinion, because it is not based on a resolution of the Security Council and neither is it based on the respect for sovereignty of states as established in the treaties.
How do we draw the line between sovereignty and if one country is feeding the next with the cocaine? But that is not a legal question, by the way.
Yes.
Yes, thank you. You reserve the right not to comment.
Maybe you may come again so that I get the question properly.
No, thank you. It's not a serious question.
Thank you, Commissioner.
Yes, thank you. Finally, to wind up, Judge, what do you think are the trends that threaten the judicial independence or the sustainability of the judiciary?
The independence of judiciary in operation is based on individual judges' independence and institutional independence. Thinking about institutional independence, I think the biggest threat is lack of sufficient funds to assure the independence of the judiciary in terms of access to justice, the infrastructure that we need, for example, assurance of provision of resources for the judiciary. In terms of individual independence, the Constitution has...
No, I don't want you to go there because I think you have answered that. The existential threat is lack of budget. What else?
Another threat to judiciary is integrity concerns, or what I may call leakage of integrity.
Yes.
And integrity first should be addressed at personal level as a conviction to do what is correct, the willingness to submit to the proper exercise of judicial authority without improper influence, like conflict of interest, bribery, and corruption.
Have you set up the integrity committees within ELRC to deal with issues of integrity?
Yes, my lady, we have set up the integrity committee at the ELRC, at Nairobi, and in the stations. And we have brought on board all the stakeholders. We have given out a matrix to our stakeholders, internal and external, to tell us what they think are integrity leakage prone areas and measures that can be taken to mitigate the proneness of want of integrity.
Finally, what do you think we can do to deal with the issue of trust deficit and also the tension around the judiciary?
One thing the judiciary can do to build public trust and confidence in the judiciary is for the judges and all judicial officers to hold high fidelity to the Constitution, the tenets of justice, and to render decisions that are responsive to the realities of Kenya's political, social, and economic circumstances. We can also build trust by upholding very high integrity standards and being honest in overriding principles. That is rendering justice that is expeditious, that is just, that is affordable, and that is accessible.
Thank you very much. I think this brings us now to the end of the interview. And on behalf of the commissioners, I would like to wish you all the best. But before we release you, we always give a candidate an opportunity to also address us. If you have anything to tell us, the floor is yours.
Thank you, Honorable Chief Justice. I really want to thank the Honorable Commissioners for the opportunity that you've granted me to have these conversations about making justice the true shield and defender of our people. And I'm committed to do justice in all the cases that will come to the court. My assurance is that judges, as pillars of courts, we are committed to do justice in a manner that is responsive pursuing accessibility and ensuring that justice is done within the constitutional tenets and provisions of the law.
Thank you very much. I wish you all the best. Keep up the good work that you're doing. We will get in touch with you when we complete the exercise. Have a very nice afternoon.
Thank you, Honorable Commissioner. Thank you, Honorable Chief Justice.
You can